would echo Mr. Cox's comments. Obviously, once is one too many times, but for most people who catch an OVI, they don't end up in court again based on alcohol-related traffic violations. This is at the very least a second occasion in which you're here. The long and the short of it is, eventually you're going to run out of luck, and something terrible is going to happen, either to you or to somebody else, or even if there's no accident or injury to anyone, you're going to sabotage your own well-being and livelihood and things of that nature. So, I would imagine that when you were sitting in the courtroom down in Lancaster back in 2011, pleading out to your OVI, you thought to yourself, well, I'll never be here again. And obviously here you are. So this does need to be the last time you find yourself here again. Understand?
Yes, sir.
Very well. On the amended charge of being in physical control of a vehicle while impaired, the court will impose a 30-day jail term. I'll suspend 26 days, give the defendant credit for 1 day previously served, and place him on probation for a period of 1 year. In lieu of the 3 days jail, he'd be required to successfully complete a 3-day driver intervention program and participate in the drug and alcohol screening and follow up any recommended counseling, if any. He's prohibited from consuming any alcohol, using any illegal drugs, or abusing any prescription medication. He is required to submit to a drug or alcohol test if requested by any law enforcement officer. He's to maintain suitable employment and follow any other rules the probation department sets that aren't expressly disapproved by the court. The fine is going to be $565, which would be the minimum on a first-time OVI at this point. Costs will be assessed, and it'll be a 1-year license suspension. Now, the defendant has not been under a license suspension this entire time, obviously, and there is no hard time suspension. Is the defendant asking the court to set this out a few weeks so that he can submit his application for limited privileges, or did he wish to get this started sooner so that it will be over sooner?
Yes, Your Honor, we got the court set out the issue of the privileges a couple weeks.
Any objection, Mr. Cox?
No.
Very well. That 1-year license suspension will start on the 25th of this month, and you are eligible to apply for limited driving privileges. I'm trying to think. Violation of the driving under suspension would be a 45-10-11 under these circumstances, would it not?
Probably.
Yeah. But if you are request and are granted limited privileges and you're driving outside of those limitations, you get pulled over, you're going to get charged with driving under an OVI or driving under a court-ordered suspension, which is also a first-degree misdemeanor, which can also land you up to 6 months in the county jail, $1,000 fine, and a 1-year license suspension. Alrighty, so amended from 45-11-19 A1A. Okay, that being said, we will give you time to pay Mr. Barr if you need it. You'll get the details in the clerk's office, but as I said, this needs to be the last time you find yourself in these circumstances. Do you have any questions, sir?
No, sir.
Anything further, Mr. Smith?
No, Your Honor.
Anything else, Mr. Cox?
No, thank you.
Very well, that'll be all. Court stands in recess. Good luck to you.
All rise.
The State of Ohio versus Grant Galoni. He's here in the courtroom today without counsel. We have Mr. Cox here on behalf of the State of Ohio. This matter comes on for further hearing, having been scheduled for a trial to the court. Defendant is charged with failure to reinstate a license as an unclassified misdemeanor and driving while under an ALS suspension, a misdemeanor of the first degree. Mr. Galoni, my understanding is that it's your intention today to go ahead and change your plea from not guilty to no contest?
Yes, sir.
All right, now before I can accept your plea, I need to go over a few things with you. The first of which is, as you sit before me, regardless of what the charge is, I have to presume that you're not guilty. Do you understand that? Do you also realize that it's always the prosecution's burden to prove guilt beyond a reasonable doubt? You have the right to be represented by an attorney. If you couldn't afford one, we give you one at absolutely no cost. I have a form entitled Waiver of Attorney here. Has your name there, the case number, a signature. Did you review the form with my bailiff? Did you understand what it said?
Yes.
Is that your signature?
Yes.
And was it your intention to waive your right to counsel? All right, very well. So, whether you have a lawyer or not, Mr. Galoni, you do have the right to a trial, and that could be with a judge or a jury in this case. Are you aware of that?
Yes.
Did you also know that at the trial you could question your accusers through cross-examination and also compel the attendance of your own witnesses through the court's subpoena power? You would have a right not to testify at the trial if you didn't want to. Nobody could force you to do so, and the decision not to take the stand couldn't be held against you in any way. Do you realize that? Now, by pleading no contest, you're not admitting that you're guilty of these offenses. You are admitting that what they say happened is true. And if those facts are sufficient to sustain a conviction, I would enter a conviction today. I would impose sentence. And although you're charged with two different theories of it was unlawful for you to be driving a vehicle that day, I'm only going to be entering one conviction and imposing one sentence. The state gets to pick which one that'll be. Mr. Cox?
The ALS, unfortunately.
Okay. So they are electing the more serious of the two charges. That's up to 180 days in jail, up to a $1,000 fine, and up to a 1-year license suspension. There are mandatory minimum penalties with that offense, which include at least a $250 fine, at least a 1-day license suspension, and at least 3 days in jail. Do you understand that? All right. And if I remember correctly, Yeah. I think this case is unrelated to the case that Mr. Galoni is currently serving a jail term for.
That's
So
correct, Your
I don't believe that the 3 days would be required to be imposed consecutively. Is that your opinion?
Do you not believe they would be consecutive?
I believe that only applies to the underlying OVI if there's a conviction along with the
I
OVI.
defer to the court. I thought it said consecutive, but I will defer.
I think it may be consecutive to any other offense charged on the same citation. If you got charged with an OVI and you were already under an OVI suspension, so they also hit you up with an OVI suspension, you would be required to serve the mandatory minimum at least 3 days consecutively to the OVI. Now, my thinking is that this wouldn't have to be imposed consecutively because it's not related to an OVI, it's just a standalone. But Mr. Cox is looking that up on his computer right now, as am I, 451014. There we go. All right.
It's odd that it says just 3 consecutive days, period.
Mm-hmm. Well, it also says that use that phraseology in the OVI statute itself.
So I don't have a problem, Judge, if that's
Okay.
the
All right.
interpretation. Yeah.
All right, so it could be imposed concurrently to the jail term you're serving now, meaning it would be an extra 3 days. Do you understand? Okay. If you plead no contest, even though you're not admitting that you're guilty, you're admitting that what they say happened is true, and if that's sufficient to sustain the charge, I would enter a conviction. Now, in a moment, I'm going to be asking the Assistant Law Director to present the facts in support of the case. I'll have you listen intently to what he has to say, because I'll be asking you if you agree with those facts, but you need to be aware that if you plead no contest, you're giving up your presumption of innocence. The state won't have to prove anything beyond a reasonable doubt other than presenting the facts, and then finally, you'll waive your right to a trial and the other rights we've discussed. Are you aware of that? All right. Now, I'm going to ask Mr. Cox to go ahead and read the facts into the record that support the charges. As I mentioned, please listen closely to what he has to say. At the conclusion of his remarks, I'm going to ask you if you agree with those facts. And bear in mind, a no contest plea, by its very nature, says, I agree with the facts. If you don't agree with the facts, then you can't do a no contest plea. Understand? Mr. Cox?
Thank you, Your Honor. On or about September 6, 2025, Township of Harrison, Lincoln County, Ohio. One, Mr. Grant Galoni, present in court today, was operating a motor vehicle, a 2018 Dodge SUV. Was spotted by one Deputy Dunlap, who had prior knowledge and was aware that Mr. Galoni had a suspended license. Got behind Mr. Galoni's vehicle, initiated a traffic stop, confronted Mr. Galoni about the lack of, or the suspensions that were in place at that time, running Mr. Galoni's registration through the mobile data terminal, rendered one administrative license suspension, BMV case SI 240-15634, imposing an ALS suspension from October 27th, 2024 until October 27th, 2026, as well as a former court OVI suspension, BMV D124011393, and the failure to reinstate status. Mr. Galoni was cited accordingly at that point in time, Your Honor.
Okay, thank you. So, Mr. Galoni, do you agree with those facts?
Yes.
All right. Now, have you been subjected to any threats or promises to get you to either change your plea, waive any of your rights, including your right to counsel, or to agree that those facts are true? Are you under the influence of anything right now? And are you still a citizen of the United States of America? Okay, very well. I'll accept your plea and waivers as being knowing, intelligent, and voluntary. The court finds that a factual basis for the charge has been presented, that the defendant agrees to those facts, and that the facts are sufficient to sustain a conviction. And I'll enter one on the driving under the ALS suspension charge. Before I make any decisions regarding the sentence, you have a right to speak. Is there anything you want to say before I decide?
I understand fully that it's my fault. I should have done more due diligence. A couple weeks prior is when the original DUS came through the Pataskala court, and I went and paid the reinstatement fee for that. And I was told at that Pataskala BMV that I was good. And I wasn't aware of the other reinstatement fee that came with the administrative suspension. And couple weeks before that, also, I talked to the Haley Akers, I believe is her name, and I was under the assumption that the driving privileges I had from the original OVI would be carried to the ALS, which was not the case. And again, I should have done a better due diligence to make sure of that. I did not mean to unlawfully drive, Your Honor. I thought
Okay. Thank you, Mr. Galoni.
I've tried, and I've been trying to get to a program to address my mental issues, health in general. Sorry.
All right. Mr. Cox, did the state wish to be heard regarding the matter of sentencing?
Your Honor, we would just know Mr. Galoni appears to be incarcerated until January 29th of next year, 2026, ultimately deferred to the court, but given his limited means at this point in time, ask the court to take that into consideration. Thank you.
Okay. So it's kind of complicated in looking at your unofficial printout. It would appear that you were convicted of OVI. Well, there was a conviction for an OVI out of Lincoln County Municipal Court in case number 24 TRC 3051, entered on 7/10 of 24, and you received a suspension of 1 year for that, which was retroactive to the date of the offense on 4/8. However, there was a new suspension that was imposed on October the 27th, 2024, presumably for a refusal, but there's no conviction for that OVI
I believe
offense.
that case was dismissed. I'm
Okay.
not privy to the details as
Yeah.
to why, Your Honor.
I was just trying to figure out why there was still an ALS, but because it was a second intent and it was a refusal, presumably, that's a 2-year ALS, and yeah, that doesn't survive the dismiss. A refusal ALS does not survive does survive the dismissal. Had you had you submitted a chemical sample or to a chemical test and tested over the legal limit and been subject to the 1-year license suspension, that would have died with the dismissal. But because it was a refusal, it survives. Now, you're still eligible to ask for limited driving privileges. And Mr. Galoni, it's not my intention to pile on you today. I recognize that you're probably at one of the lowest points of your life right now. And I hope that it is, but I don't mean that in a malicious way. I mean that in an encouraging way, in that if this is as bad as it gets, then you'll know what you need to do to get back up to where you want to go. And you've got some time to figure it out. So I would use the time constructively. Don't sit around playing cards or bullshitting with the guys.
Every
Keep to
day
yourself.
I try and talk to social. I'm trying really hard to get, because I remember when you sentenced me, you had mentioned that I had a mental health issue, and I mean, my wife left me. I'm trying to get to a program or something. I promise I'm not sitting there dicking around.
And I believe you, Mr. Galoni. I mean, listen, I've been up here long enough, and I've sat at those tables long enough before that it's pretty easy to recognize crocodile tears. I believe you're truly suffering. The question is, and of course, really, what are you going to do in response to that? Because if you do the appropriate and the healthy things, you're going to find yourself back on the right track, probably reestablishing at least some semblance of relationship with your wife. You guys have kids together? Yeah, that's what I thought. So, I mean, you're going to be family for the rest of your lives, whether you're together or not. You can't be a healthy part of that family until you're healthy yourself, and that's what you need to work on. And yeah, keep bombarding the medical department as far as, asking to have a mental health assessment arranged. Those social service agencies will come into the jail to conduct assessments, so.
I had one with BHP this morning, and
Okay.
I had a letter for you also, and they wouldn't let me bring it, so I'll mail it, but
Okay.
I'm trying really hard to get, because I mean, I need it.
Right.
And I just want to be the father that my kids deserve.
Yeah, how many kids do you have?
Well, one that's mine.
Okay, and how old is that child?
She'll be 2 December 7th.
And how long had you been in the other child's life, and how old is that child?
3 years, and she'll be 5 in upcoming here in a couple weeks. 4.
Okay. Now, is her dad still involved?
Yes.
Okay. What's your daughter's name?
Marley.
Okay. Well, Mr. Galone, like I said, right now, you're serving a penance, as it were, for past transgressions. But this court is a firm believer in treatment, and so, I'm not going to pile on, as I mentioned. It's just going to be the 3 days. I'm not going to impose them consecutively, so the next 3 days count towards this sentence. It's an additional $250 in fines and costs and a one-day license suspension. The only practical effect you'll have from that is there will be an additional reinstatement fee. It's not nearly as expensive as the OVI reinstatement fee is, however. So, you've got, at this point, about pretty much got about 90 days to figure out what happens when you finally get out at the end of January, and how you're going to ensure that you're addressing the reasons why you find yourself where you are. And if you can have everything set up prior to your release, that's going to be even more likely that you're going to be successful in trying to address those. So you're going to need extra time to pay, so in about another 2.5 months, make sure you write me a letter asking me to extend the deadline by which these fines have to be paid, and I'm more than happy to do that, because it's obvious that you can't make money while you're in the jail. At least you better not be making money while you're in the jail. And we'll get you an ample amount of time to pay this off.
Is there any way that you would potentially consider, like, me going to a program in lieu of?
If you're screened by a residential treatment program and they recommend that you would benefit from it, I wouldn't ignore it. I'm not saying I would grant it, but I would probably have an oral hearing and want to hear what probation had to say about it. So I can't remember, your PO is Miss Weaver, correct?
Yes.
Yeah, that's what I thought. So, you may or may not know this, but she was the probation officer attached to the drug court program back when it was up and running. So she's very familiar with, the issues that accompany these substance abuse cases, and as well as the mental health places. Most of these residential programs will treat both, which is important, because you have to treat both simultaneously to be successful. So, yeah, I'm not precluding it. I'm not saying it would happen, but I'm saying at the very least you would have to be screened and have a spot offered to you before I would consider that. Okay? And again, you're going to want to coordinate that with the medical department.
Yeah, I believe I've already been screened.
By what program?
DHP.
That's just a local mental health provider. They don't have residential treatment programming. I'm talking like places like Mended Reeds or the Recovery Center, or.
That's where I'm trying to get to Mended Reeds,
Yeah.
but
Okay.
they're
Well,
waiting for an attorney.
yeah.
So.
Keep trying, and in the meantime, like I said, keep your nose clean in the jail and keep on track with what you want to do when you get out. You have any other questions today?
No.
Anything further, Mr. Cox?
No, thank you.
All right. Well, Mr. Galone, you're going to go with the bailiff. Good luck to you.